Welcome once again to Know Your Rights University in association with Natural Essence Compact LLC. We are back at you again with another video, hoping that the information that we share with you today will be beneficial to you and your family. Let us begin. This video is going to be called What You Have Can Be Taken, whether it be through lawsuits, probate, taxes, or seizure. These are not rare misfortunes, they are systematic outcomes. They are baked into the public ownership model. When your home, business, bank account, or investments are titled in your personal name, you invite exposure to litigation, to IRS scrutiny, to creditor garnishment, and or to the probate system intervention or probate court. Your name on title equals your name on a target list. Let us begin with a reading of a Supreme United States Supreme Court case. Uh, and there's a distinction which we will get into a little later between the United States Supreme Court case and the Supreme Court of the United States. We believe it has something to do with public versus private rights and or going into an Article 1 court as opposed to going into an Article 3 court created by the Constitution. Let us begin with the reading of this case. Case is called Dry et al. Versus United States. And it is a trust case concerning this individual's rights to his inheritance of his mother's estate. Let us begin. This case concerns the respective provinces of state and federal law in determining what is property for purposes of federal tax lien legislation. At the time of his mother's death, petitioner Ron F. Dreyer Jr. was insolvent and owed the federal government some $325,000 of unpaid tax assessments for which notices of federal tax liens had been filed. His mother died intestate, leaving an estate with the total value of approximately $233,000 to which he was sole heir. After the passage of several months, Dry disclaimed his interest in his mother's estate, which then passed by operation of state law to his daughter. This case presents the question whether Dreyer's interest as heir to his mother's estate constituted property or a right to property to which the federal tax liens attached under 26 U.S.C. Section 6321, despite Dreyer's exercise of the prerogative state law, accorded him to disclaim the interest retroactively. We hold that the disclaimer did not defeat the federal tax liens. The Internal Revenue Code's prescriptions are most sensibly read to look to state law for delineation of the taxpayer's rights or interests, but to leave to federal law the determination whether those rights or interests constitute property or rights to property within the meaning of Section 6321. Once it has been determined that state law creates sufficient interest in the taxpayer to satisfy the requirements of the federal tax lien provision, state law is inoperative to prevent the attachment of liens created by federal statutes in favor of the United States. The relevant facts are not in dispute. On August 3rd, 1994, Irma Delilah Dry died intestate, leaving an estate worth approximately $233,000, of which $158,000 was personalty and $75,000 was realty, located in Pulaski County, Arkansas. Petitioner Ron F. Dreyer Jr., her son, was sole heir to the estate under Arkansas law. There's the law concerning intestate interest passing first to the children of the intestate. On the date of his mother's death, Dreyer was insolvent and owed the government approximately $325,000, representing assessments for tax deficiencies in years 1988, 1989, and 1990. The Internal Revenue Service had made assessments against Dry in November 1990 and May 1991, and had valid tax liens against all of Dry's property and rights to property pursuant to 26 U.S.C. Section 6321. Dry petitioned the Pulaski County Probate Court for appointment as administrator of his mother's estate and was appointed on August 17, 1994. Almost 6 months later, on February the 4th, 1995, Dry filed in the probate court and land records of Pulaski County a written disclaimer of all interest in his mother's estate. 2 days later, Dry resigned as administrator of the estate. Under Arkansas law, an heir may disavow his inheritance by filing a written disclaimer no later than 9 months after the death of the decedent. The disclaimer creates the legal fiction that the disclaimant predeceased the decedent. Consequently, the disclaimant's share of the estate passes to the person next in line to receive that share. That's interesting right there. Let us read that again. The disclaimer creates the legal fiction that the disclaimant predeceased the decedent, meaning he died before his mother, by claiming rights under this statute. Then it says, consequently, the disclaimant's share of the estate passes to the person next in line to receive that share. The disavowing heirs, creditors, Arkansas law provides, may not reach property thus disclaimed under that section. In the case at hand, Dry's disclaimer caused the estate to pass to his daughter, Teresa Dry, who succeeded her father as administrator and promptly established the Dry Family 1995 Trust. On March 10th, let us back up for 1 second. The daughter established this trust after the father disclaimed his interest in his mom's estate under state law, which that interest, the state law granted that it passed to the heir of the father or the disclaimant. And thereupon, the heir, Teresa Dry, who succeeded her father as administrator, promptly established the Dry Family 1995 Trust. On March 10, 1995, the probate court declared valid Dry's disclaimer of all interest in his mother's estate and accordingly ordered final distribution of the estate to Teresa Dry. That's the state probate court. Teresa Dry then used the estate's proceeds to fund the trust, of which she and, during their lifetimes, her parents are the beneficiaries. Under The trust terms, distributions are at the discretion of the trustee. Dry's counsel, Daniel M. Traylor, and may be, excuse me, right, and may, let's read that again. Under the trust terms, distributions are at the discretion of the trustee, Dry's counsel, Daniel M. Taylor, and may be made only for the health, maintenance, and support of the beneficiaries. The trust is spendthrift, and under state law, its assets are therefore shielded from creditors seeking to satisfy the debts of the trust's beneficiaries. Also in 1995, the IRS and Dry began negotiations regarding Dry's tax liabilities. During the course of the negotiations, Dry revealed to the service his beneficial interests in the trust. Thereafter, on April 11, 1996, the IRS filed with the Pulaski County Circuit Clerk and Recorder a notice of federal tax lien against the trust as Dry's nominee. The service also served a notice of levy on accounts held in the trust name by an investment bank and notified the trust of the levy. On May 1st, 1996, invoking 26 U.S.C. Section 7426A1, the trust filed a wrongful levy action against the United States in the United States District Court for the Eastern District of Arkansas. The government counterclaimed against the trust, the trustee, and the trust beneficiaries, seeking to reduce to judgment the tax assessments against Dry, confirm its right to seize the trust's assets in collection of those debts, foreclose on its liens, and sell the trust property. On cross motions for summary judgment, the district court ruled in the government's favor. The United States Court of Appeals for the Eighth Circuit affirmed the district court's judgment. The Court of Appeals understood our precedents to convey that state law determines whether a given set of circumstances creates a right or interest. Federal law then dictates whether that right or interest constitutes property or the right to property under Section 6321. We granted certiorari to resolve a conflict between the Eighth Circuit's holding and decisions of the Fifth and Ninth Circuits. We now affirm, under the relevant provision of the Internal Revenue Code, to satisfy a tax deficiency, the government may impose a lien on any property or rights to property belonging to the taxpayer. Section 6321 provides, if any person liable to pay any tax neglects or refuses to pay the same after demand, the amount shall be a lien in favor of the United States upon all property and rights to property, whether real or personal, belonging to such person. 26 U.S.C. Section 6321. A complementary provision, Section 6331A, states, if any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the Secretary to collect such tax by levy upon all property and rights to property, except such property as is exempt under Section 6334 belonging to such person, or on which there is a lien provided in this chapter for the payment of such tax. The language in sections 6321 and 6331A, this court has observed, is broad and reveals on its face that Congress meant to reach every interest in property that a taxpayer might have. See also Gloss City Bank versus United States, where it was said stronger language could hardly have been selected to reveal a purpose to assure the collection of taxes. When Congress so broadly uses the term property, we recognize, as we did in the context of the gift tax, that the legislature aims to reach every species of right or interest protected by law and having an exchangeable value. Section 6334A of the Code is corroborative. That provision lists property exempt from levy. The list includes 13 categories of items. Among the enumerated exemptions are certain items necessary to clothe and care for one's family, unemployment compensation, and workers' compensation benefits, Section 6334A1, 2, 4, and 7. The enumeration contained in Section 6334A, Congress directed, is exclusive, notwithstanding any other law of the United States. No property or rights to property shall be exempt from levy other than the property specifically made exempt by Section A, Section 6334C. Inheritances or devices disclaimed under state law are not included in Section 6334A's catalog of property exempt from levy. Wow. So that's saying that state law that the father used to try to escape or in that case, I guess it would be evade. Maybe in his mind, he thought avoid the tax liability that had been assessed against him and the lien that had been filed in that county in Alabama against him, against his rights to property or his property and his rights to property. This law says, or this statute under the IRS code says that inheritance or devices disclaimed under state law are not included in Section 6334A's catalog of property exempt from levy. The fact that Congress provided specific exemptions from distraint is evidence that Congress did not intend to recognize further exemptions which would prevent attachment of federal tax liens. United States versus Mitchell. The language of 6334 is specific and it is clear, and there is no room in it for automatic exemption of property that happens to be exempt from state levy under state law. The absence of any recognition of disclaimers in sections 6321, 6322, 6331A, and 6334A and C, the relevant tax collection provisions contrast with section 2518A of the code, which renders qualifying state law disclaimers with respect to any interest in property effective for federal wealth transfer tax purposes and for those purposes only. Dry, nevertheless, refers to cases indicating that that state law is the proper guide to the critical determination whether his interest in his mother's estate constituted property or rights to property under Section 6321. His position draws support from two recent appellate opinions, Leggett versus United States, where it was said Section 6321 adopts the state's definition of property interest, and Mapes versus United States, where it was said, for the answer to the question whether taxpayer had the requisite interest in property, we must look to state law, not federal law. Although our decisions in point have not been properly phrased so meticulously as to preclude Dry's argument, we are satisfied that the code and interpretive case law place under federal, not state, control the ultimate issue whether a taxpayer has a beneficial interest in any property subject to levy for unpaid federal taxes. As restated in National Bank of Commerce, to question whether a state law right constitutes property or rights to property is a matter of federal law. We look initially to state law to determine what rights the taxpayer has in the property the government seeks to reach, then to federal law to determine whether the taxpayer's state delineated rights qualify as property or rights to property within the compass of the federal tax lien legislation. CF Morgan versus Commissioner. State law creates legal interests and rights. The Federal Revenue Acts designate what interests or rights so created shall be taxed. In line with this division of competence, we held that a taxpayer's right under state law to withdraw the whole of the proceeds from a joint bank account constitutes property or the right to property subject to levy for unpaid federal taxes, although state law would not allow ordinary creditors similarly to deplete the account. National Bank of Commerce. And we earlier held that a taxpayer's right under a life insurance policy to compel his insurer to pay him the cash surrender value qualifies as property or a right to property subject to attachment for unpaid federal taxes, although state law shielded the cash surrender value from creditors' liens. By contrast, we also concluded again as a matter of federal law that no federal tax lien could attach to policy proceeds unavailable to the insureds in his lifetime. It would be anomalous to view as property subject to lien proceeds never within the insured's reach to enjoy, just as exempt status under state law does not bind the federal collector. So federal tax law is not struck blind by a disclaimer. Thus, in Mitchell, the court held that although a wife's renunciation of a marital interest was treated as retroactive under state law, the state law disclaimer did not determine the wife's liability for a federal tax on her share of the community income realized before the renunciations. See this Supreme Court case where it was said, right to renounce does not indicate that taxpayer never had a right to property. The Eighth Circuit, with fidelity to the relevant code provisions in our case law, determined first what right state law accorded Dry in his mother's estate. It is beyond debate. The Court of Appeals observed that under Arkansas law, Dry had, at his mother's death, a valuable, transferable, legally protected right to the property at issue. Although code does not define property or rights to property, appellate courts read those terms to encompass state law rights or interests that have pecuniary. The court noted, for example, that a prospective heir may effectively assign his expectancy in an estate under Arkansas law, and the assignment will be enforced when the expectancy ripens into a present estate. Dry emphasizes his undoubted right under Arkansas law to disclaim the inheritance, a right that is indeed personal and not marketable. See brief for petitioners 13. Right to disclaim is not transferable and has no pecuniary value, but Arkansas law primarily gave Dry a right of considerable value, the right either to inherit or to channel the inheritance to a close family member, the next lineal descendant. That right simply cannot be written off as a mere personal right to accept or reject a gift. In pressing the analogy to a rejected gift, Dry overlooks this critical distinction. A donee who declines an inter vivos gift generally restores the status quo ante, leaving the donor to do with the gift what she will. The disclaiming heir or devicee, in contrast, does not restore the status quo, for the decedent cannot be revived. Thus, the heir inevitably exercises dominion over the property. He determines who will receive the property, himself if he does not disclaim, a known other if he does. See Hirsch, The Problem of the Insolvent Heir. This power to channel the estate's assets warrants the conclusion that Dry held property or a right to property subject to the government's liens. In sum, in determining whether a federal taxpayer's state law rights constitute property or rights to property, the important consideration is the health of the control, is the breadth of the control the taxpayer could exercise over the property. Dry had an unqualified right to receive the entire value of his mother's estate, less administrative expenses. Confirming that unqualified right to receive property is itself a property right subject to the tax collector's levy, or to channel that value to his daughter. The control reign he held under state law, we hold, rendered the inheritance, property, or rights to property belonging to him within the meaning of Section 6321, and hence subject to the federal tax liens that sparked this controversy. For the reasons stated, the judgment of the Court of Appeals for the Eighth Circuit is affirmed. And there you have it. Despite his right, or his so-called right, that he claimed under the state statute to disclaim his interest in his mother's estate as heir, so that that interest could go to his heir or his children or his daughter. Under federal law, because of his so-called obligation or tax liability assessed prior to all of this transpiring, he had no right to try to evade or to avoid his tax liability, and therefore the IRS gangstered or confiscated what he had left or disclaimed, so that his daughter could receive the inheritance of his mom. This shows you, we believe, that without properly, prior to any type of tax liability being assessed against you, any type of judgment being rendered against you, is accomplished if you or I have not properly structured our estate, meaning our property and rights to property, not in our own name, but in some sort of entity other than our own personal name or title, such as a trust or something to that effect. What we have can and will be taken. We thank you once again for listening to Know Your Rights University in association with Natural Essence Compact LLC. We hope this information has been of benefit to you. We look forward to meeting and greeting you again in our next video. Thank you once again. Peace and blessings to you all.